Hi, Emma. Thank you, Emma, and hi, everyone. It's good to see so many of you here today. Some new faces along with some familiar ones, some of my clients that I know very well. So welcome to you all. The topic of handling disciplinary hearings is the most common form of case for me and my team here at THSP Risk Management. Getting it wrong can cause ill feeling or even embarrassment if the warnings on file cannot be relied upon because of a step out of line. Unfair dismissal claims are the most commonly received by Her Majesty's courts and tribunal services from disgruntled qualifying employees. There are two main factors for this: that the dismissal was disproportionate for the offence, and that is going to be based on case by case and the allegations and the events that have happened, or that it was procedurally flawed. The latter is the most common and it's avoidable, and that is what I'm going to focus on for the next 20 or 30 minutes, so please bear with us. Firstly, do let me share one of my experiences. I've been there in management. I've been a director and manager of other companies. And one of my experiences, particularly when I go back to earlier in my career, some years back, I learned a really hard lesson, which was to set out everything clearly and concisely in writing, along with what I expected to happen. I ended up losing some money. A great deal of time was invested putting it right. And I lost some pride. I'll hands up and admit to that. The lesson in life is the same for employment-related issues from my perspective. And anything that is not captured in writing with expectations and objectives not only fails, but is also likely to change the direction of issues in hand, i.e. they're likely to turn full circle and come back on the disciplining manager and the business in fullness of time. The steps I'm about to discuss need to be followed meticulously, but they're not difficult. Miss any of these steps out, then like me many years ago, you're likely to find yourself back at the first base having to start again. So now that we've set the scene, let's get started. We've all had those situations where an employee is giving you a headache and you wonder what you can do. At this time, it's always best to step back and reflect. Take some advice and plan your actions carefully. Reactions from the hip get embroiled in emotion and can often go wrong. Here's an example of the type of email I get on a daily basis from our customer. Can you draft a letter for me? Member of staff requesting holidays and was denied, then didn't come to work on those days. In fact, I had one of these just yesterday afternoon, same situation. The client asking me, can I produce a written warning to be given, as their attitude around this is also poor. And they've also had, when I think about it, a lot of sick days. There are lots of facts and issues there to consider, and to jump straight to a warning would fall foul of the expectation, the procedures of handling a disciplinary hearing fairly. Does it all sound familiar to you? I'm sure you've all been in this situation, that you all know of experiences that you've had to rely upon, issues that you've had to deal with. Just to set the scene, I'm going to ask my colleague Emma now to launch a poll to gauge how you feel about handling disciplinary hearings. It's anonymous to everybody else here, so I'd be grateful if you could express your feelings at this point in terms of being very confident, not so confident, or if you need help. We can see those results, but be assured that nobody else on this webinar today can see them at this time. I'll give you 20 seconds or so just to lodge your views. Okay, there we go. The results, as I say, are in. So we've out of the 20 or so people today, we've got 13 that are very confident, 31 confident. The majority, though, not so confident, and one or two need some help. As I say, it was only yesterday that I had a call from someone wishing to escalate a warning to dismissal. On review of the facts, I established to do this would have been automatically unfair and a breach of the rules around disciplinary action. So what are these rules? You might find it strange that while there is nothing written into the relevant sections of the Employment Rights Act about the procedures to be followed, reference is made to recognised minimum standards. What are these minimum standards, you might ask? Well, ACAS have these minimum standards that have been set out for 25 years. And the minimum standards set out in the ACAS Code of Practice for dealing with disciplinary and grievance matters put some process in place and steps to be followed. Some companies do choose to have more elaborate and detailed procedures in their contracts of employment or their handbooks. These are typically negotiated and required by trade unions when they have formal recognition. But by and large, I find most of my clients have to rely upon, and we refer them to, the ACAS Code of Practice. This is what I'm going to talk about in more detail very shortly. At the first sign of an issue arising, it's really important to stop. Don't react to it on the spur of the moment. It may be that you need to suspend the person from work. This can be done by an authorized manager. Usually that is referenced within your disciplinary policy and terms and conditions. They need to know about how serious the allegations against them are. I had a case not too long ago when somebody assaulted a colleague with a hammer. That was serious enough for me to suspend them because of the risk to others. In terms of suspension, the line in the sand is around the point of harm to other people within the business or the business itself, such as an ongoing theft. Take some time at this point to think about the situation. Once you get an appreciation of what's happened, then you need to decide whether it's now reasonable to suspend this person on full pay or keep them at work while the investigation continues. As I say, suspension should only be considered in the most serious of cases, where there's an ongoing risk to people or your business. Case law suggests that to suspend somebody without due reason suggests that you've already made the decision to terminate their employment without following procedure, without considering the facts. Disciplinary procedures can be tricky and need to be handled carefully, as with the suspension, it can influence the rest of the process. As I mentioned, it's not always necessary to suspend someone if they've acted in gross misconduct. In every case, involving suspension or not, then following the process is really important. I'm going to talk you through these steps in the next few slides, but let me first say that if you don't follow the ACAS Code of Practice, then any claim brought by this disgruntled qualifying employee could automatically be judged as unfair. And if that is the case, because the procedure has not been followed, the courts will apply a 25% increase on the award to that complaining individual, the claimant in this case, that has been awarded to them by the courts. So before we jump into that, just to put some figures onto this, some monetary figures onto this, can I ask you, using the chat function, to put what you believe to be the average award for an unfair dismissal claim based on the current employment law tribunal statistics from HM Courts and Tribunal Services? I'm just going to give that a couple of minutes while people use the chat function. Okay, we've got a few coming in. 10, 12, 13, 25. We're going up. It's like an auction. This is 25,000, 20, 20, 19, 20, 30, 22. Okay. Good. Should we stop there? Yeah. Let's 40 pats later. Okay. According to HM Courts and Tribunal Services, the average per claim for an unfair dismissal claim is £11,000, probably a little bit lower than some of you were thinking. But add on to this the cost of defending it, legal fees, a barrister to go to court, their preparation time. You're talking between £750 to £1,000 a day for a barrister to be in court for you. The time that this all takes to defend a claim, somewhere in the region of 12 to 18 months currently, from the point that the ACAS are involved in early conciliation through to the hearing date. And the disruption this causes to the business, it takes eyes off ball, it disrupts business in terms of what its prime objectives are going to be. It also potentially damages reputation. Sometimes you have to disclose tribunal awards in your tenders, your prequels, and I said it's publicly available information. That said, I'm not one that sits on the fence. If an employee has acted in misconduct or gross misconduct, I'll ably support my clients to make sure that they get to the stage that they lawfully need to and want to get to. I say follow the ACAS code carefully and ensure you can demonstrate that you have in case of a claim it's been made. I often get asked, can we just sack them? But once we've taken some time to understand the circumstances for each employee, it becomes clear as to why we need to follow the code. So I'm going to take you through the 5 steps of running a disciplinary hearing properly. Allegations throughout this process are going to be made. These are not necessarily the facts, as they could be personal opinions and views of other people. Remember that old saying of innocent until proven guilty. This principle must be adopted by anyone involved throughout. So the first stage is to identify you've had an issue arise, a situation has occurred with an employee, maybe more than one employee, and you believe that action needs to be taken. So first, decide who is going to be involved. Ideally, and I know not all businesses are geared up to do this because of their size, but ideally, to run a fair process, 3 individual people will be involved. 1 to investigate the matter, 1 to carry out the disciplinary hearing, and 1 to hear the appeal after a decision has been made. As I say, in some cases, this is not possible, and the law respects that. But fairness still needs to be maintained. Appoint somebody for the appeal, appoint somebody for the investigation, and appoint somebody to carry out the disciplinary hearing. The 3 things, 3 important things to try and apply from the outset. I would always recommend that you start by appointing the last one first, the appeals officer. This person is then completely left out of discussions or investigations on the matter. They don't need to know anything at this time. So when they have to decide if the process has been carried out in a fair way, they are not influenced by their own opinions or those of others at the very early stages. Equally, they must be in a position to overturn or change any previous decisions. So it's quite often for the chairman, the chief executive, the managing director to act in this position of appeal manager. All you need to tell them at this stage is Johnny's been accused of misconduct and you're running an investigation that may lead to a disciplinary, and ask them if they're okay to act as the appeal manager should it come to that stage. Keep it really simple. Now we've got the second person to consider. This is the investigator. They must be completely impartial to the alleged offence, so they can't be involved. They can't be the person who has been perpetrated against. They can't be a witness to this. It's not their job to judge. They've got to be impartial and objective in their investigations. Their job is to find out as much as they can of what's happened. As I say, they must not be involved in any later further disciplinary action either. This investigator is not going to be the person conducting the meeting. Where they can, they must collate all evidence. This may be electronic or written documents, statements from witnesses, CCTV, dash cam evidence, or other records, so long as they're legal, or a statement from the accused, which is also really useful. The investigating officer must present all of this evidence to the nominated disciplinary officer, and this evidence must be made available also in time to the accused employee if disciplinary action is going to be considered. So any witness statements that have been collected from individuals that experienced, that saw what happened, or holding information that could be really important to the outcome of this decision, need to know that their statements will be made available to the accused before a disciplinary decision is taken. The only time that you can withhold that information if the person's health, safety, and well-being is deemed to be at risk from the accused. So now we need the third person, the disciplinary officer. It's for this person to consider three things. So the grounds of the investigation, what the investigating manager has managed to uncover. The alleged conduct, is it misconduct? Is it gross misconduct? Is it a breach of contract? And what actions may come out of this disciplinary hearing? Some of those may be no action, some may be first written warning, final written warning, or even summary dismissal. If they think there's going to be a breach of company policy, then a disciplinary hearing may follow. Now you're ready to invite the accused person to a disciplinary hearing. Are you ready? So how do we invite them? Send them a letter or an email, but not a text message. We need to be able to trace that this has been sent to them. In your letter, you must tell them what they've been accused of. We're going to come on to that on the next slide. This can be posted by recorded and standard post. That's what I recommend. But it could also be emailed and put a read receipt, a delivery receipt on there. Equally, it can be hand delivered if they are still at work, but make sure they understand that the letter, the envelope is of real importance and significance to them. So once you've told them why they're being invited, there are three more important facts. Tell them what they are accused of and what sanctions these offences can carry. So poor attendance, poor timekeeping might be an act of misconduct, might be a first written warning, whereas a physical assault, harassment, intimidation of somebody could be an act of gross misconduct that may warrant summary dismissal. You have to share at this point any evidence, including these witness statements, that are then going to be discussed at the meeting. So make sure the people who have written the statements, as I've already said, know they will be shared to the accused. Include the date, time, and location of the meeting, and confirm who will be attending the disciplinary hearing. So the manager, the disciplinary manager, and the note taker, and any witnesses that have been called to the hearing. Finally, make it very clear that they have the right to be accompanied at the meeting. Usually a work colleague or perhaps a trade union representative if they're recognised by someone. Or just being reasonable, someone else, maybe a relative, a parent, a guardian, particularly for apprentices that are coming to disciplinary hearings. It's important that they're involved. The only thing you need to avoid is to avoid bringing a clever lawyer, perhaps like myself, coming to the meeting, calling the shots. They'll just make it difficult for you. I know, I've been there, and they just don't have the legal right to attend. So just be open-minded with that, apart from a solicitor, a lawyer, or a barrister. So then we come to the meeting. We've got to the date, the location, everybody's in attendance. So the disciplining manager then introduces those present at the meeting and clarifies the role each has to play. For instance, the chair of the meeting, the note taker, and what the companion's rights are. The meeting can be recorded, but has to be with everyone's agreement. Make it clear that the employee's companion can confer with them or ask for clarity on something that has been said, but they cannot ask or answer any questions on behalf of the employee. The employee needs to do this themselves. Set out the reasons for the meeting. It's already in the letter, but make it clear, make sure everybody understands. Reiterate what the allegations are and what possible action may result in this. Ensure the employee has received everything and read through all the supporting documentation, because this meeting is really their chance to defend or offer reasons as to why they believe they are innocent in the allegations. Talk through the matters and listen to the response of the employees. As I say, it's their chance to offer their side, what they've been accused of, and offer any explanation as to why things have gone wrong. For example, you were seen taking money out of the till on Saturday. Well, I couldn't have been because I was at the rugby on Saturday. You know, those kind of mitigations are really important, and this meeting is the opportunity for the employee to put those forward. No further information must be brought up by the disciplining manager in this meeting if it's not already been shared. Just listen to the employee. If anything is raised that cannot be proven or requires further investigation, then the disciplining manager can stop the meeting and agree for the meeting to be reconvened at another time or date. It's really important to control this and take time to make sure every avenue has been explored. Do not make any decisions in this meeting. It's really important that time is taken afterwards to reflect on what has been said. So when you finish discussing everything, ask everyone around the table if they have anything else to add. Then end the meeting and tell the employee they will have their decision in writing within, say, 48 to 72 hours. You can also, at this point, advise the employee what you expect of them in this intervening period. It may be to go back to work if they've been continuing while the investigation is carried on, or if they were suspended, then that will carry on until your decision has been made. So once you're happy that all possible time and effort has gone into dealing with questions arising from the meeting, then gather your thoughts. Think objectively about the allegations. Evidence collected, responses from the employee, and options available to you, as they're all important in your decision making. It's not only important to demonstrate a fair process, which we're talking about here, but also that the decision taken must be reasonable. Case law dictates what is reasonable, and it basically asks what a reasonable person would do in such circumstances. Emotions need to be put to one side, and it's really good to speak to us at this point to ensure that the process has been followed and the decision that is likely to be made fits within these reasonable responses, even if we've not been involved before. When you're ready to inform the accused, the outcome needs to be put in writing. The outcome could be anything, as I've mentioned before, from no action through to summary dismissal, with first and final warnings in between. State your reasons for coming to your decision in this letter. Also provide a copy of the minutes that the note taker has prepared, or if a recording has been taken, make sure that audio file is made available to them. It's not necessary for you to be drawn into debate about the minutes or your decision, but in your outcome letter, you will have made it very clear that the steps taken can now be appealed against, and who that appeal should be made to, the time that they should be made to that appeal manager, and the format that it should be made in. That should all be very clear in the outcome letter. So quickly, 3 things to remember. Tell them your decision and why. Provide notes or recordings of the meeting, and tell them who to appeal to. Okay, we're right at the end here. Something comes up that in this statutory process is the final right to appeal. It's the final step the employee has to appeal against the decision that the disciplinary manager has taken. You've given them the timeframes, the format and person to contact for the appeal in the outcome letter. The person you've agreed to act as the appeal manager must have the power to overturn the decision made by the disciplining manager. And this appeal manager must not have been involved in any stage so far. They have to be independent to review all the steps taken and information relied upon by the person making the decision to sanction disciplinary action. So they need to fully understand the process that has been applied as well. The appeal manager will then go through the same process of setting up a meeting with the employee and their trade union representative or work colleague or parent, guardian, family friend, should they wish, to discuss the appeal. Any further investigation follows, and the appeal manager then draws their own conclusions on the process, and if the decision made to sanction disciplinary action was reasonable. The outcome is put in writing from the appeal manager, and their decision is final. Okay, so same questions as we asked in the first poll, if we might, Emma, please. We're going to launch this second poll just to ask how you now feel about running a successful disciplinary hearing. Again, I'll give you 20 seconds or so to edit an input. Over to you. Okay, how are we looking? That's great to hear. It feels like I've done my job when I see an improvement in the poll. Most people are now in the confident to very confident bracket. One person perhaps still feels a little uncomfortable, and I'm happy to have a further one-to-one conversation with them after this meeting. Thanks for your input with that. So before we go to Q&A, for anyone wishing to discuss this subject matter or any of our great range of services further, then please put a yes in the chat box now. And my colleague, either Emma or Shani, will be in touch with you to arrange a call. As Emma mentioned, as a thank you for attending today, we're going to send the recording of this webinar to you all. Please feel free to share it. It will be out on our newsletter today as well. So anybody who's not attended can see that. And the webinar, as with all our building suite of webinars that we're producing now, are available on YouTube. So Q&A, feel free to connect with me, please, on LinkedIn to keep up to date with most current developments affecting employers and businesses. You know where we are if you need expert help. And remember, there are significant savings to be made in seeking help first, rather than getting tied up in a tribunal claim. Hopefully, we've covered all of that. So I'm just going to jump into the chat box now and see if anyone's got any questions. If you don't feel comfortable with posting it in this forum today, then contact me or apply for one of these discovery calls, and I'll happily give you a call and talk through the situation. Any questions? Just to confirm, if you suspend someone, is it on full pay? Hi, Liz. Yes, it is. They suffer no detriment to any of their employment terms and conditions. So full pay, holiday accruals, pension contributions. I want to talk about full pay as well. As we've gone through furlough and calculating furlough claims, it's important to remember that the law says normal pay and not basic pay. So if somebody retains or earns regular overtime as part of their role, as I know some of Liz's people do, it's important that their pay while suspended is the average of that rather than say they're 40 hours a week. Hope that is clear, but any questions, let me know. Brian, where can I get a copy of the ACAS standard? It's on my THSP, Brian, if you're one of our clients. Otherwise, Google ACAS Code of Practice, Disciplinary and Grievance, and you'll find it not a problem. It'll be your top search on the normal Google Safari searches on the internet. Anyone else? Thank you, Ian. Really appreciate your comments. Okay, shall we draw it to a close? Okay, firstly, thank you, Paula. Thank you all for attending this morning. I hope it's been useful. As I say, we're building a suite of webinars now that are available to everyone through YouTube and on my THSP, the client portal. If there are any questions anybody has, do contact me. Please do connect with me on LinkedIn, keep in touch, and come back to me if you've got any questions. Thank you all for attending. Have a great day. Hope the sun's shining where you are, and hope to see you all again soon. Thanks. Bye-bye.